Welcome back to the show, everybody. Check out these headlines. We got more insolvency on the way in the crypto space. What can turn this market around? I believe I'm going to show it to you today. And one former SEC lawyer tells the assistant regional director of the SEC that ETH and XRP are not only similar, XRP is a currency token. You're going to want every bit of that, as well as crypto trial of the century, the SEC versus Ripple, and a new Ripple filing. Somebody roll that beautiful intro.
Digital Perspectives with Brad Kimes. Come on in.
Welcome back to the show, everybody. You can follow us on TikTok, YouTube, Twitter, and Facebook at the top of the screen for exclusive content. Right now, we are looking at a $1.120 trillion market cap for crypto. A lot of money coming into space overnight, but not as much as we've seen with a $3 trillion plus market cap. But that's due to the suppression of the lack of clarity put on this market here by U.S. lack of clarity and regulation from the agencies and respective agencies. Bitcoin right now, 23,800 plus. Ethereum, 1,700, almost $1,800. XRP at the number 6 spot, 37 cents right now. It's August 10th, 2022. Good morning, everybody. Right now, the price is ranging between 35 and 38 cents. It's a pretty wide. I mean, it's, I've seen it tighter. We'll keep an eye on it. However, we will hear on some TA and what's shaping up. But what you need to know about is what's shaping up at Link2 right now. With any investment portfolio, the more variety of stocks you add to your portfolio, the better diversified you are. Well said, Ray Fuentes from Link2.com. And to prove it and make it easier to do, if you are accredited, if you are already a Link2 member, click this link or the one underneath my videos to make sure that you get the special happening this weekend, which is $5,000 minimums to be able to widen and diversify your portfolio or deepen the ones you already have. Take a look at this. 200 million XRP transferred from Ripple OTC distribution wallet to unknown wallet. And, I asked the question again. Jed McCaleb is sold out of 9 billion XRP. Ripple has not sold any XRP to a non-ODL retail exchange since Q4 of 2019. I ask all of you to help me figure out where is the retail non-on-demand liquidity exchanges going to continue to get the XRP from going forward. Now, that does not discount the fact that Jed McCaleb sold 9 billion XRP. So there may be a heavy float out here of that XRP. It may take some time to draw all of that up and dry up the retail. We shall see. And if I'm wrong, I'll make the video, but I don't know that I am. And no one's been able to tell me where to get it. And what is the incentive, by the way? What is the incentive of an on-demand liquidity partner selling to a regular exchange? Retail is not driving price at this point from where I'm sitting. United States retail investors have been largely limited, thank goodness for Uphold, to getting XRP. And if you think about that, they've already begun to try to squeeze out from retail, starting with US. And what happens if this ends up playing out and becoming accurate, that what is out here is all that will be left for retail to get a hold of, especially if there's a ruling in the case that reinforces that notion. We'll keep an eye on it. Look at this. Singapore High Court has granted the parent company of crypto lender Vauld DeFi Payments Ltd a 3-month protection from creditors, noting this would allow Vauld to restructure and prepare for a potential acquisition by competitor Nexo. We'll keep you up to date on that. And this right here is more of a cascading effect of insolvency. German company crypto exchange Nuri applies for insolvency due to the crypto winner The crash of the crypto market and collapse of the crypto lending services Celsius network were the main reasons that led that company to file for insolvency. So again, that cascading effect. What can fix and solve this certainly is some regulation, right? You know, these companies like Celsius were registered companies with the proper agencies. But as Caitlin Long so eloquently said, just because you're registered with an agency doesn't mean you're regulated. And Celsius proved to be evidence of that. And now we see that cascading effect stemming. What can fix this? Here, I'll tell you what I think can fix it. It's a U.S. stablecoin bill delayed with custody involved, probably, to be able to deal with that custody and requirement there. And that's been pushed back to what we know is September, they say, October if we're lucky. We will keep an eye on it, but there are more concerns that need to be addressed with stablecoins in bankruptcy, which I just went over. And if they address this and get it right, ladies and gentlemen, if they get this right in the stablecoin bill, I really believe, because everybody's like, well, I can't invest in stablecoins. No, you can't. You can put your money there. It's like a digital dollar. But the reality is that this on and off ramp is so important. I believe, and I've heard other congressional figures say this as well, and I do believe it. A stablecoin bill, albeit may not address more than stablecoin bankruptcy and maybe some slight custody issues. But the reality here is if they get that right, it will be as explosive as the Telecommunications Act was in 1996 for the birth of the internet. That light touch approach allowed trillions and trillions of dollars to pour into this space, understanding what was in front of them in the way of regulation. Now, let's get to the case. And before we do, let's set it up with this clip because this gentleman says it just about as right as you can. The SEC's approach up until now has been to go after the smaller companies, the DeFi money market and others of that nature, to set precedent through regulation, through enforcement, through a decision in the case, and then to build regulation through enforcement and how they operate based on the judgment and precedent in those smaller cases. Listen to this clip.
And so if the Howey test, which was built in the land of orange groves and real estate deals in Florida, that's the 50s case, can be interpreted in the context of golf course memberships, I think it can also be interpreted in the context of cryptocurrency. My problem with what's going on right now is that nobody ever goes to court and fights it out. The SEC would prefer to take parties down that they can easily settle with, get a settlement and get someone to apologize for doing what they do. Settlements don't leave legal precedents. They're not binding on anyone except the two parties that settle, the SEC and say Ether Delta, or the guy who developed Ether Delta. So we need the SEC to go after bigger parties who maybe they're afraid to go after because they know they'll fight it out in court and they'll have good lawyers and a lot of money to spend. And we need those parties to not settle, to say, you know, I'm going to fight this all the way up to the Supreme Court. And then we'll get the clarity with respect to this test. And it'll come from the bottom up. It'll come from a fact-based context, not just someone in Congress or someone in an agency opining from on high about how things should be regulated.
And I mean, I don't know if you could say it any better. And I think the Ripple case may, in fact, go all the way to the Supreme Court. But remember, we get a favorable decision at this level. Ripple can operate, start bringing in U.S. customers, while that appeal may go all the way to the Supreme Court for finality and decision of what these things are, and certainly what XRP and the XRP ledger truly is. And I think at that point, then there's no question, and you can really, truly operate. I do believe something will go the distance, and certainly Ripple is absolutely in a position to go the distance, and we're about to find that out now. The parties are filing their responses to the motions to exclude expert testimony, but remember, it is all under seal now, so there is nothing to see. But those of you who follow docket services will get notices that things are being filed on the docket. Jim, we thank you so much for all the information, and he's getting ready to hit us up with some more, because Ripple responds to the SEC's objections regarding the Hinman email ruling. Oh my goodness, it is so good. as always, and take a look here. The Ripple defendants have filed their response to the SEC's objections to Magistrate Judge Netburn's decision on the deliberative process privilege issue and the attorney-client privilege issue. Let's get started. There's quite a few things to see here. I just brought some highlights for us. The SEC challenges only how Judge Netburn exercised her discretion in applying the correct standard after examining these issues for many months, including reviewing many of the very documents in question. Now, one of the things I'll say is that, that's one of the things that, look, I know that in court, parties can challenge a judge's ruling and decision-making, but remember, judges are people too. That's all I can say about that. So the SEC has done nothing but piss the judge off through this process, especially in the last couple months here. The SEC is unable to show, says Ripple, as it must, that Judge Netburn clearly erred in determining that there was any possibility that the information sought may be relevant to the subject matter of the action. It cites a case here. And it says, to prevail on its relevance objection, the SEC must show not only that there is no possibility that the documents could be relevant for any of the aforementioned or other purposes, but also that the Judge Netburn erred in applying the broad discretion afforded to the magistrate judges in holding that they were relevant. Again, stepping on the toes of the judge here. I understand that is normal procedure for parties to push back on a judge's decision, but judges are people too. The SEC does not come close, says Ripple, to clearing this high bar. Oh, they certainly don't. And here we see another section here. The speech conveyed Hinman's views as to how the federal securities law could apply to Ether, a digital asset with marked similarities to XRP. And you know what? In just a second, I'm going to play you a video of a former SEC lawyer who's going to tell you the same exact thing and calls it a currency token. And you're going to want every bit of that. And he does it while talking to Steve Buchholz, the assistant regional director of the SEC. Yeah, how about that one? Drafts of and discussions concerning the speech could reveal the extent of which the facts that made Ripple's scheme illegal were so obvious that the defendant must have been aware of them, such that discarding them would be reckless. For example, the drafts and communications may touch upon what and how much was previously told or not told to market participants about other digital assets that are similar to XRP or XRP itself. The discovery may reveal what information the individual defendants and other market participants had in determining whether a digital asset was a security. I love that Ripple's team are pressing on this issue even harder to say, you know what? It is so vitally important that we see the email thread on all of this because it can tell us exactly what was talked about. And then we can compare notes about how clear things were or were not to us and everyone else in the space. I just love this. Make no mistake about it, I firmly still believe the SEC will not let any of us or Ripple see these emails, and that really will push us somewhere. As noted above, these communications may reveal that the SEC itself was unsure how to communicate information to market participants, distinguishing digital assets that, according to the SEC, are not securities, Ether, from those that now allege are XRP. Faced with these same arguments, Judge Netburn rejected the assertion that this court has imposed a new narrow view of relevance in the context of discovery in its March 11th order. Then there's this right here. Shout out to the adult in the room who highlighted this as well. This is as hard as the burn gets right here. The SEC's real objection appears to be that Judge Netburn did not accept the SEC's invitation to retreat from her findings when the SEC, apparently realizing belatedly the legal implication of its efforts to characterize the speech as a personal outside activity of Hinman. Sought to put the toothpaste back in the tube and rely on self-contradictory lawyer argument to avoid the consequences of its litigation strategy. Damn! But that was not error. It was the faithful application of law to facts. The SEC's objection must be denied. Damn. Let's get to this clip right here because you're going to want it. SEC trial of the century is what they call it earlier. You won't hear them say it in this clip for the sake of time. But the SEC's Assistant Regional Director, Steve Buchholz, who was on stage 2 months ago with Matthew Solomon making inside jokes back and forth about the Reeves test. Former SEC lawyer John Barry says ETH and XRP are similar, and XRP is a currency token.
Obviously, we're hopeful that we'll get another positive outcome in litigation.
John and Mike, I mean, you're listening to Steve or even just looking at SEC filings. All you do is apply this 80-year-old Howey case and SEC wins. That's it, open and shut. I mean, are there defenses or is it hopeless?
The SEC, I think, has gotten more aggressive. I think that the Telegram and Kick cases, I thought were pretty aggressive cases. And I certainly would put Ripple in that category. I mean, you look at Ripple itself. I mean, it's a token that's been around since, I think, 2013. And it's a lot like this other currency called Ether, which is a lot like Bitcoin. Ether started, and the founders of Ether used the token to raise money to help build its platform. And now Ether is out there and can be used just like Bitcoin to buy goods and services. But the SEC has not and has never brought a case against Ether. And so I think that's an interesting comparison when you look at Ripple and Ether being so similar. Now, the SEC is going to point out certain things about Ripple that could make it different. Ripple, they would say, marketed its XRP, it's kind of an XRP token as an investment. Its founders made money by selling it. Ripple's not quite as decentralized as Bitcoin. Bitcoin has, I think I mentioned earlier, these people called miners, that third parties who are not affiliated with Bitcoin at all are just third parties out there making money by confirming these transactions, which is called mining. Ripple doesn't really do it that way. It's one of its sort of what it advertises as a good part of the way its token works. It doesn't have these miners. And these miners have to, instead it has what are called validators who are more affiliated with the company. So there are arguments that the SEC can make that will say that this fits within Howey, but when you're looking at a currency token like XRP, which is the Ripple token, a currency token like XRP, which is the Ripple token, it's being used and has been used for almost 10 years to buy goods and services. It's a tougher argument under Howey because, you can argue that it's more like getting a Bitcoin, which is you're not investing in something, you're just getting something like cash to buy things. And I think it's going to be interesting to see how this plays out. I think.
Oh, it sure will. And not only is it going to be interesting to see how it plays out, it begs the question, why did the SEC wait almost 10 years to take action against XRP? Why did the SEC approve the MoneyGram partnership between Ripple and MoneyGram to use XRP, understanding that MoneyGram would be using an unregistered security according to the SEC? All these are great questions and more. Not financial advice from me or anyone else, and I'm certainly not a lawyer, so make sure you take that with you today. But this is getting interesting, ladies and gentlemen, and I tell you, I'm really excited to see September and October come around as a final thought here and to get this stablecoin legislation. I really do believe if they get that right, it will be as electrifying as the Telecommunications Act for the Internet of 1996. I'll catch all of you on the next one.